The trial court has fixed the date.
I'll request all of you, please kindly give your memos. Please give your memos. Please give your memos. I'll go through and.
20 ତାରିଖକୁ ଅଛି ସାର୍ ତଳ କୋର୍ଟର।
ଆମର 1 ତାରିଖ ଦିନ ମେମୋ
adjournment ନେବେ ଆଉ କଣ?
ସେ 311/12 1 ତାରିଖ ଏଲାଉ ହେଇଥିଲା।
ଦିଅନ୍ତୁ ମେମୋ ଆଣିବି ମୁଁ ଦେଖୁଛି।
Madam, to make a mention, item 33 may not taken about next week.
33
On
this list.
this supplemental list.
All right, next week.
Interim order to be continued.
Item 45 minor.
Good. Just okay. Yes.
Item 45 minor. Permitted to withdraw minor.
Supplementary list. Permitted to withdraw.
IA.
Item 38 of the supplementary list. I have already filed the requisite manner because of my mistake I failed to file. I have already filed today morning.
You let it reach.
Item 19 minor next week.
Item 19 next week.
Item 25 loads can next week loads.
25.
Yes,
Next week.
supplement list.
Hello, item that is it is connected with another matter TRPCRL 26 and 2000 that is listed to 22 August 2024. So kindly put this matter along with that matter. On 22 August 2024.
Item 19.
34.
Item 34.
Same respondent, same petitioner. And we have
All right,
taken
let's just matter on when you what?
22 August 2024.
On 22nd August. है ना?
Minors. WPC number 1864/2009. This case has been heard. I have to file a written.
Please.
No, minutes. I submitted it on Monday.
All right.
Because of my illness, I
All right.
Item 33 interim order continue. Interim order to be continued.
Interim order to continue.
33 item.
Yes.
33.
Yeah.
Judgment item 1.
For the foregoing reasons, therefore, the writ petition is partly allowed. The opposite party authorities are granted pay of the post of system manager to the petitioner from the date he held the same as in charge till the date of his retirement. Such pay, less the amount already paid to him, shall be calculated and disbursed in his favor along with all revisions of pay that may have taken place during such period. His last pay drawn should be fixed accordingly, and his pension and pensionary benefits, if any, be also revised accordingly. It is further made clear that any amount paid towards career advancement such as ACP, RSCP, etc. shall be duly adjusted. The whole exercise should be completed within a period of 2 months from the date of production of certified copy of this order by the petitioner. Item 2. In the result, the writ application is disposed of by modifying the impugned order to the extent that the date of joining of the petitioner shall be treated as 29/12/1994 and that of opposite party number 4 as 14/3/1995, and the interest seniority shall be reckoned accordingly. Connected matter, in view of the judgment passed today in so and so, this writ petition is disposed of accordingly.
3.
For the foregoing reasons, therefore, the writ application is allowed. The impugned order under Annex 10 is hereby quashed. The CTPO Raghunathpur is directed to reinstate the petitioner in service forthwith. It is made clear that the period between the date of disengagement and her reinstatement shall only be notional for the purpose of continuity in service without grant of any financial benefits.
4.
It will go to connected. Okay. In the result, the writ application is allowed. The impugned order of disengagement dated 7/3/2022 is hereby quashed. The opposite party authorities are directed to reinstate the petitioner in service forthwith. The petitioner shall not be entitled to any financial benefits from the date of his disengagement till reinstatement, but his services shall be notionally counted for the purpose of continuity. The connected writ applications are disposed of also in light of this.
5.
In view of the above findings, the writ petition is allowed. The impugned order of termination dated 28/12/2022 enclosed as Annexure 5 is hereby quashed. The petitioner be reinstated in service from 28/12/2022, but he shall not be entitled to any back wages.
Item 6.
I mean, pardon, Bill, item 16. Let's say minute here. That
Item 16.
16. Mr. Mishra is appearing.
All right. Item 16 lays this matter before any other bench, as I am concerned.
Item for case family matter from Talcher to Bhubaneswar.
Culture to Bhubaneswar.
Yes.
Take notice. Notice. Yeah. With this
I have
matter.
filed one IA also.
Are you the
Today filed one.
Right.
36. I'm giving the copy.
The IA is not there on record.
Today I have filed one.
Let it come on Monday then, along with the IA. I can IA 3 kintu order pass kiri. Or call for the IA? Mandru, call for the IA from this section. File each will see. Aji file each. Tale register hoina thio, let it come on.
236. IA.
Hela itere urgent kon ache ke? Let it come on 20th. Hela. List this matter on 20th along with IA number
236.
236 of 2020. Hela season order hobo. Yes. Dar. ମୁଁ କେବେ କଲି? Oh,
Okay,
sorry.
okay.
12. ଭୁଲି ଯାଇଛି ସେ ଇଏଟା ଜଣା ପଡୁନି. Yes, item 7.
7.
7 मतलब cordial lordship's order, my lord. या धनंजय चरण दे.
କରିଦେଇଛନ୍ତି?
Yes, my lord, correct.
Disposed of.
Eight.
Similar case will also have passed around court. When a petition has been continued, since 2004. Case was considered for regulation. Direction was given for to consider his representation. Now government has rejected annexure 6, which is.
Annexure 6.
Yes, ma'am. On the ground that the petition was appointed as affected in the Bushigasa Vindani case. Similar case will also has one case will also pass September.
No, Rishikesh Bindhani was passed because those persons were appointed from the list without
Without
advertisement. Therefore, this court directed that you go for a fresh advertisement, and accordingly, a fresh advertisement was also issued.
15
Is it covered by my judgment? Have I passed any judgment in this regard? I think
Notice similar case re best pending to notice notice decide ହେଇନି କିଛି 5 ବର୍ଷ
I have decided. Next section.
এটা মেট্রোটা পেন্ডিং আছে
pending ଅଛି
আটলিস্ট মাই
I think I passed a judgment today with him. Ajiro judgment, देखिए. Judgment.
এই যে এন ঈশ্বর রাও
Yeah, N. Vishwa Rao is different.
ইয়েস
That is on the ground of equivalence.
ସେଇଥିରେ ସେ ଋଷିକେଶ ମିଣ୍ଟାଣିର ଏଟା ମାନେ ଷ୍ଟାଣ୍ଡ ଟାକୁ ଆମେ ନେଇଥିଲେ but they were protected.
Yes. That is what I have dealt with.
Yes.
No, because there was an instruction of the government
26
that even if these candidates have not been reselected, they will continue. And no further order recalling that order has been passed. That is why I have held that no, you cannot. And subsequently another plea was taken in that case.
Yes.
Anyway, we will issue notice.
Yes.
Sri S.N. Patnaik Learned AG accepts notice for all the opposite parties. Let a counter be filed. Place this matter on
5 बोलছি ଗୋଟେ case
5 rows to
5
on 5th September. Yes.
the same entry order was
What entry model?
no question.
All right. Till such time, no coercive action shall be taken against the person.
Nine.
This is cover matter. GRS myth. My lord already disposed yesterday. I have a similar case, man. I have. Some sort of approach the collector, mera and sir 6 is value.
ଆପଣଙ୍କର କଲେକ୍ଟର ପୁରୀ
My lord.
ରିପ୍ରେଜେଣ୍ଟେସନ ଡେଟେଡ
Dated my lord.
ସେଇଟା ଏଠି
PC 7 ଦିଅ
ସେଇଟା କରିକି ଦିଅନ୍ତୁ
my lord annex করে ଅଛି
ଏଇଥିରେ କରୁନାହାନ୍ତି କି ଏଇଥିରେ କରିଦେଲେ ହବନି ସେଇ ଅର୍ଡରଟା ପାସ୍ କରିଦେବୁ ହଲେ ଡିସପୋଜ ଅଫ ସେଇଟା ସେଇ ଯୋଉ ଅର୍ଡରଟା ଦେବେ ସେ ଅନୁସାରେ ବସିକି କରିଦେବୁ ପେନସିଲ କରିଦେବୁ ୟେସ୍
Item 10.
My lord, one Passover, my lord.
ଅଲରେଡି
11,
Pass over. Pass over.
12,
The last date was the instruction call for from
Madhusudhan.
Madhusudhan.
Oh, Madhusudhan, yes, ma'am. My lord, in this case,
Just.
on the last occasion.
Just. The question to query post by the Director of Secondary Education, the District Education of the Kendra first the category wise space vacancy. Yes. How was that vacancy
My lord, that is
adjusted?
what, my lord, previously, my lord, that 2-7 order was not actually uploaded and I got that some other instructions. But on the last occasion, your lordship handed me a copy of the 2/7/2024 order, my lord. I have already in my lord. And today in the morning hour also, my lord, I contacted them. Actually, they want to, it is only to be listed next week, my lord, so that they can provide that information. Your lordship has specifically observed that a letter of the DEO, which has been sent to the director, it has been indicated that with respect to the orthopedically handicapped, one vacancy is indicated in the year 2013. Whereas in the recruitment advertisement of November 2014, that orthopedical handicap
There is no such
is no
vacancy.
there. So how that particular post has
So
been
that
filled up,
vacancy must
whether
not
it has
have
been-
vanished into thin air.
Yes, that is. This will be taken up next week, madam.
All right. Sri S.N. Patnaik Learned State Council submits that he is to receive the required instructions in course of the day and requests for adjournment. Place this matter next week, next Friday. Again? Next Friday, good date.
So next one, see.
13,
I am applying for the OC number 3.
Who's for the petitioner?
Chavos.
Last occasion, lordship has directed take instruction, my lord.
My lord, with respect to the
Notification establishing ECC at Mangod as also at Ektali.
My lord, I have got the instruction, my lord. May I be permitted to provide that? My lord, there are two schools, my lord. One is at Mongod and another is at Ektari. Now, with the ECC center, my lord, whether it was at Ektari, whether the ECC center at Mongod will be taken into consideration for the purpose of awarding the mark at Ektari or not, my lord. That is what the action has been taken, my lord. That is by adding some more mark to the party concerned, my lord, in this case, because for the service she had rendered as is in the ECC center. So your lordship wanted to know that with respect to the establishment of the ECC center. Now, the ECC center established under the school mass education department, that is the school's matter, not by the Anganwadi officer. So after I wrote a letter to the concerned CDPO matter, the CDPO contacted the two headmasters of the two different schools matter, and what the documents matter they could collect matter, that is the document what they have provided.
You file them in the form of an affidavit.
I'll file the matter.
Learned State Council has obtained the required documents which this court has produced. Let these be furnished in the form of an affidavit after serving copy on the other side. Place this matter next week.
Sir, next week, days.
All right. Place this matter on 23rd August.
23rd, most of it.
for admission item 14.
Pass over. जे ना दे pass over कर दूँ तब देखिए author देखिए.
Item 14, my lords, may pray for next week, my lords. I have been engaged in this case today, my lords. I pray for next week, my lords.
Sir, I'm unable to see you.
I don't understand. There is some problem in the laptop, my lord.
Unless I see you, I cannot pass any order. No. Sorry, sir. Sorry, sir.
Pass over, lords. Pass over. I am coming to the.
All right. Pass over.
Lords.
15,
Pass over. 16 টা তো গলা
Seventeen.
পাস ওভার কর
20 open equal.
পাস ওভার হো
18.
ইনো আসবে ডিসপোজ অফ করে দেবো
19.
But 19 increment is there next week. I prefer next week. Highlight a missing message.
Please this matter next week as paid for.
But increment is there.
Into order to continue.
20.
Pursuant to an advertisement dated 25/8/2007, my lord, petitioner applied for the post of Gram Rozgar Sevak. Here petitioner has assailed the order dated 27/7/2011 passed by the project director DRDA, wherein DRDA has upheld the selection of OP number 4 and further directed that the OP number 4 will continue as Gram Rozgar Sevak of K. Binayakpur Gram Panchayat of Basudevpur block. Lordship, kindly have a glance at Annexure 4, the advertisement,
Annexure.
page 18.
Yes.
Lordship, qualification, second column qualification. Is +2 pass. Preference will be given to candidates having computer proficiency of O level with use of Odia language in computer. Commerce students will get preference. Thereafter, my lord, criteria for selection, my lord. Selection will be made strictly on basis of marks obtained in the 10+2 examination. Thereafter, preference will be given to the candidates belonging to the concerned GP area, then the concerned Panchayat Samiti and the Bhadrak district in case of suitable candidates are not available in the same GP or block. My lord, the marks on basis of mark obtained in the 10+2 examination. Thereafter, my lord, preference. Lordship, kindly have a glance at page 14 for a moment, my lord. Page 14. Next page, my lord. Sorry, my lord, page 19. Sorry, my lord.
Yes.
Page 19. My lord, this is the these are the candidates. My lordship, can come to page 20. My lord, I am Manjulata Panigrahi, serial number 14.
Yes.
But I have secured 527 out of 900, my lord, in +2 examination. And my lord, the selected candidate is Kamalakanta Naik. She has 500 out of 900, my lord. My lord, she has PGDCA course and I have also, my lord, PGDCA course. But my lord, despite she has secured less marks than me, she has been selected. And on ground of preference, my lord. My lord, preference, that is a Honorable Supreme Court judgment, my lord, which says that preference does not mean en bloc preference. Preference will be given when everything will be equal. When there
I have rendered a judgment. I have myself rendered a judgment in this regard, relying upon the Supreme Court judgment relating to preference. Maybe not in case of this Gram Rozgar Sevak, but in case of some other case.
My lord, I have a judgment of the Honorable Appellate.
Please. So what was you both belong to Basudevpur Bhadrak? That
Yes,
is,
my lord.
so what was the reason for giving preference? Agar kon tapar dikhya lota.
Yes, my lord. Lordship, may come to the rejection order, my lord, which I want to challenge, my lord. Page 26.
Page 26, yes. Pardon. Page 26 ne kuri final order ta koti.
Lordship, may come to page 30.
30, yes.
Last paragraph, my lord.
Yes.
Inquired into the matter, where is the records of the selection committee, previous and court's order, petitioner and the OP number 4. The selection procedure was decided under the chairmanship of collectors. It was resolved that the percentage of 10+2 marks, qualifying marks, will be taken as a base mark. Preferential marks for commerce stream and 6 marks.
Preferential mark 4 for commerce.
Sorry, my lord. 4 for commerce stream and 6 marks for computer O level to be added. As regards genuineness of passing computer O level, the institution having accreditation of DOEG will be taken into consideration and computer certificate from this institution will be accepted. As DOEG is an autonomous body, Government of India, Department of Electronics and Telecommunication institution, my lord. Telecommunication, the institution accredited to such society taken as genuine. The petitioner submitted a computer certificate from Microcomputer Education, which is not accredited to DOEG society. Hence, in view of the above fact, the marks which has been kept for computer proficiency could not be awarded to the petitioner, and as such, she stood in 4th position in the selection list of the said GP. But the OP number 4 secured 1st position in the selection list of the said GP, as he has been awarded 6 marks for computer proficiency of certificate from CRAC Bhubaneswar, which is a DOEG approved institution. Hence, considering all the above facts, I came to the conclusion that Sri Kamalakanta Naik, OP number 4, is genuinely selected for the post and order that Sri Naik will continue as GRS in K. Binayakpur GP of Basudevpur block, and the case is disposed of today, my lord.
So your case is something else.
Yes,
It
my lord.
you were given preference, but your candidature was not accepted because of that certificate.
My lord,
Now we have to decide
Yes.
whether that certificate, rejection of that certificate on the ground of absence of accreditation,
Yes, my lord.
whether that was correct or not. You have proceeded on a different level altogether. Saying that preference should not have been preference was granted to that person. That is why she was elected. No, you were also granted preference. Computer qualification was considered,
Yes,
but
my
your certificate was not accepted. That is not the same thing as what has been decided in this
the
case.
advertisement, there is nowhere written that you have to produce a certificate of DOX.
That's a different matter.
Yes,
So
sir.
what you started by saying that wrongly preference has been given, and you are referring to a judgment which does not at all is not applicable to this case at all.
Well, when the base mark is 10 than +2, my lord, I have secured more marks in 10 than +2. How can engagement by virtue of
No,
preference, my lord?
no. There is the advertisement provides. Let us go to the advertisement. Let us read it again. What does it say?
Page 18, my lord.
Selection will be made strictly on the basis of marks obtained in the 10+2 examination.
Examination, my lord.
So supposing that mark is obtained, thereafter preference is to be given.
Thereafter preference, my lord.
Yeah. So as between two persons, if somebody has this computer qualification, ये जो computer का था तो नहीं ठीक होती. हाँ. Preference will be given to candidate having computer proficiency of O level. So that's the general.
It is.
As between two persons,
Yes, my lord.
one having computer qualification and the other not computer qualification, then the person having computer qualification will be preferred. That is what the
Yes, my lord.
summon substance of the
Yes, my
You
lord.
have a valid point when you say that you have scored more marks, so you should have been considered. What is the counter?
Counter paragraph 15, they have justified the selection of the opposite party on the ground that has been reflected. The petitioner has submitted a computer certificate from my.
Is there any interim order passed in this case?
No, my lord.
2007 no matter. Anyway, but this is very difficult to sustain.
The private party who has been selected.
Dekhan. What is the meaning of preference? Mr. Das,
Pardon.
two. One has computer qualification, the other does not have computer qualification. So the person who has computer qualification will be preferred. This is the meaning. All things remaining equal, candidates with the added qualification or higher qualification, whatever, they will be preferred. Here what has happened is, they have taken into account.
So,
he has been considered because he has a computer qualification. Apart from the fact that he is he has the highest marks in the 10+2 examination, which is the base mark.
yes.
He has the computer qualification. They reject it on the ground that the certificate is but they have not accepted. So that the computer DOAC, that it should be accredited to DOAC, that should have been mentioned in the advertisement. There is no such thing. Simply
We have said in the counter only in fact.
No. In the notification, it is silent. It simply says candidates having computer proficiency O level with use of Odia language in computer. That's all. So how can you say that since it has not been accredited to DOAC, it is not a valid certificate?
That could not have been said.
So that is what has been said.
In the counter, the same thing has been said also.
Right. Procedure prescribed in letter number 18/8/2017. अच्छा हो.
The selected candidate perhaps has not.
The question is, it's too late in the day now because the other person must have been selected and he must be working. It's too late in the day.
Has also appeared, my lord.
That I know. All right, third and part. On 30th August. 30 August କେତେ ଅଛି ପାଠରେ କିଛି ଲେଖା ହେଇଛି ଦେଖିଲେ? ନାଇଁ ନା 30 August କରିଦେବା ଦେଖିବା. Yes.
Obvious, my lord.
Item 15, your lordship was pleased to pass over. I pray for next week.
Item 15.
15.
Next week. Yeah, that one.
21.
My lord, seeking passover.
Item 21.
Yes, my friend is seeking for a passover, my lord. I am selling on her board. The next item, if there is an amendment application, may it be allowed? If your lordship so desire.
Already in item number 21.
Oh.
Oh, yes, I do. There was a direction to the state administrator to get the update status and latest instruction, my lord, in this regard. We have sought for it, my lord. Some time may be given next week. my
In
lord.
paragraph 15 of the counter filed petition, wherein stated that the government has been releasing idle salary, which is causing a burden on the state. The building and land are lying unused. If such is the situation, the court would like to know the decision of the government, if any, with regard to the future of this organization. What would be? This is a valid, this is a very pertinent question that I've asked.
That is where, my lord. We have intimated them, my lord, but today at the late hour, my lord, I received the file and I could not. give it to
बहुत
them.
दिन देरी है
This matter will be taken up
Okay.
next week.
ये देरी है
Next week.
नेक्स्ट
Next week. I'm
डेरी
doing
तो
for-
हो गया कौन करे बोले Is this matter next week as paid for? नहीं देखो the learned state council requests for an adjournment on the ground that the instructions sought for is likely to be received very soon. List this matter on 16th
Yes.
August. It is made clear that and on that we allow that amendment.
My, because that I am only apprehensive that that might further delay. Your lordship have been pleased to issue notice to them long back, almost a year back. It's
All right,
a
we'll see. Let us see. आइए कहते
IA Hutri 13518 of 2023 arising out of WPC number 10985 of 20.
what amendment do you want?
Amendment, my lords, I need to incorporate 4 or 5 documents of the state government itself. They clarified in a meeting and they upheld it and concurred it that the persons or employees belonging to the SIET will be governed by the state government service rules. So if that be so, then your lordship may feel it appropriate to treat us to be covered in the state government rules. And in the event of
No, but if the SIET institute itself is no longer in existence.
yes, if that is no longer in existence, but the state government remains. There are number of organizations, corporations with the state government.
No, if I remember correctly, there were 2 classes
Yes,
of
my
employees.
lord. Yes, my
One
lord.
directly employed by the
Yes, my lord.
SIET
Yes, my lord.
And
other deputed by the state government.
Yes.
So the
Now-
state government employees will go back to their.
My lord, here is there is a
That is the-
crux, my lord.
Please, my lord.
Yes, they might be deputanist when they join SIT, but after 10 years they were absorbed in the SIT, for which we stand in the similar footing. Then on what basis, by discriminating, they have again these deputanists, they have sent back to the state government organization.
Further self-
And we are
The catchword is, my lords, SIET had no rules. Maybe an autonomous organization, they themselves framed a rule and stated that state government service rules will be applicable to SIET employees, even if they are a separate entity as they nomenclature it, but the service conditions is covered by the state government rules. If
Not-
that be so, then I hope your lordship would.
You have any objection to the amendment being allowed?
They can.
आइए next case राज connected matter to next case सब item है ना आइए 13518 of application for amendment of the writ petition with the purpose of incorporating
Consolidated.
certain
Tomorrow.
documents and pleadings and
Tomorrow.
to include Union of India, Department of Human Resource Development, bracket Education, as opposite party number 5. Learned State Council, on whom a copy of the amendment application has been served, has no serious objection to the prayer for amendment being allowed, as the same is formal in nature. The submissions, the IA is allowed, consolidated writ application
By Monday.
be filed by Monday. Further,
Union of India is already a party.
No, but he has made a party. Schedule of
No,
amendments.
in my writ petition, I not. Second writ petition. It is
So,
not the first writ.
Can you accept notice on behalf of?
I will serve a copy on my land.
Let a copy of the writ petition, consolidated writ petition be also served upon Sri Bimbisar Das, who shall represent opposite, the newly added opposite party number 5. List this matter.
16th.
16.
16, all right, 16.
I am also appearing for NCRT. In the first case.
NCRT doesn't have to say.
Doesn't have any role to play, but it has been made an opposite party.
Caution. As an abundant caution.
More the
Caution.
merrier.
More the merrier. He doesn't know about the structure.
22.
Grateful mind.
Pass over to camera.
22.
22.
In respect of appointment of Anganwadi worker, my lord, though I have been selected, but the post was directed not to be filled of the advertisement was concerned. That is under challenge. Stage operating since counter has not been served.
Is counter necessary in this case?
Yeah, we have already played a counter bill since 2021.
It's not on record? Is not on record? Give another copy. And what is the matter?
I have also not.
You have not received the counter? All right.
But it is
No,
scanned copy. I think my lord,
it is neither on record nor a copy has been served on the petitioner.
may be permitted to.
File kariye to.
It's sanctioned.
Then State Council files
Also, I'm serving.
a copy of the counter in court. Let a copy be also served upon Sri Purohit, learned counsel for the petitioner, who may file a rejoinder. Rejoinder darkar hobe tatha who may file a rejoinder if so advised. List this matter on 30 तारीख पत्र केबे शुक्रवार होछि हैं नहीं 30 तारीख परे
6 बजे 6:24 6:09 sir 6:09
सेपटे देख 6 September 6th ऐसे ऊपर ता अछि दूसरा कोन दोछ ऊपर ता कोन छ anyway yes
23.
कोर्ट रो पिटा कोर्ट पे
23 can be taken up next week, my lord.
why
Well, my senior will argue this matter.
all right 23 next week
Obligement.
24.
in that item now 23 I think my lord, the original copy is already available, but I am supplying another. There are 22 items. Or counter.
चल दी scan in yes
May pleasure. Last application on Lordship on 19/7/2024. I have given the disability latest assessment of disability.
you have to take instruction on that assessment.
My lord, we have not received any respect to that latest instruction, the medical certificate which has been produced, my lord.
As per the direction of the
The DA is the district project coordinator of Raigada, my lord. I have contacted him, my lord.
the SC medical college that is
No, they have to consider it.
Next week you obtain these.
Yes, ma'am.
as per the direction of honorable court, she has conducted disability.
Yes,
I understand
yes, and this is
as requested by Land State Council as requested
Yes.
My lord, next week, my lord,
as requested by Land State Council is this matter next week. The previous order be complied with.
Yes.
26.
Yes, item 26. Chalo. Arjun Nikhil. 26 pass over.
27.
27.
And at the time of posting, and he was in charge of the Pitha program. And the Pitha program, he has his own pocket. And the opposite party 5 has not the bill has not been clear and a last failed certificate has not been issued. But after transfer of the NSC Kamakanagar, and subsequently opposite party has filed the counter, and the counter he has a is opposite party filed a counter, and in counter is very severe allegation against the petitioner lordship. So it is a rejoinder must be required lordship file the rejoinder, because I would file the rejoinder against the count of the number 5. Neither they have paid the money in Pitha program, because I have money has been spent in my pocket, and mortgage the gold ornament of my wife, and that has been auction. The gold ornament already been auction, because after when I asked to there is a dispute between the executive officer and the petitioner. Subsequently, they have alleged against me.
All right, land counsel to the petitioner wants to file rejoinder to the counter affidavit filed by the state. Place this matter on 6th September, rejoinder if any be filed in the meantime.
Problem.
28,
Pass over,
28,
pass over, pass over. 28,
29,
28, pray for time.
28.
Yeah, miss, yes, ma'am.
3rd कारण
Pardon?
September पर 6 हेले 13 September as paid for.
Obligement.
29,
I am appearing on the behalf of Mr. Balaram Naik. Lordship, the opposite party have instructed.
बरं ठीक आहे ठीक आहे रिक्वेस्ट करू बाहेर ठीक आहे असं कथा करू
2022 for the decree of divorce filed by him before the Lord and Judge Family Court Bhadrak has been withdrawn by.
What is your name?
Utkal Kesari Naik.
Utkal
Kesari Naik.
Kesari Naik, appearing on behalf of who is this?
Mr. Balaram Naik.
On behalf of Sri Balaram Naik, Land Counsel for the opposite party submits on instructions that the case sought to be transferred, that is CP number 108 of 2022, pending in the court of Judge Family Court Bhadrak, has been withdrawn by the opposite party husband. As such, the transfer application has become infructuous and is disposed of as such.
May I pardon to mention the item 10 Vasomer Monday only. I have taken the consent of
Item 10 next week. No, Monday night, Friday.
for next week.
Friday. Monday तो कोटा अलगा प्रकार ये से तो अपने इंटरफेयर कर जो.
ताले 22 तारीख next week 14 16 ता ठीक है उसका.
Friday ही ऐसे. It will come only on Friday.
Then on 23rd.
23rd.
Item 14 minutes.
No, please. This is not mentioning time, sir. This is not mentioning time.
This is a transfer petition, praying for transferring the maintenance petition from Talcher to Denkanar. But they are intentionally not appearing, the notice is sufficient. My lord, in the meantime, I filed one additional affidavit stating that this particular petition is that CLMC is disposed of. Now there is a case pending under section 125 clause 3. Filed an additional affidavit.
No, here,
At the time,
which case do you want to transfer?
my lord, initially I filed to transfer criminal 3 of 23. At the time of filing, we are not
92
aware
of
that,
2023.
my lord.
92 of 2023.
Yes, my lord.
Pending before SDGM Talcher.
Yes, my lord.
Now what happened?
The time of filing, this matter were disposed of. Now they have filed one case under section 125(3) for recovering the areas of.
This has been disposed of.
Yes, my lord.
This matter.
Yes, my lord.
The disposed of matter which has come. Sir,
I was not aware of that. The matter were disposed of. We are not appearing because we are contesting one matter here.
which matter was disposed of, sir?
In 93 of 2023.
92 of 2023.
93, sir. Sorry, 92. I'm sorry.
So that was disposed of. So this is disposed of as not for, I mean, infructuous, so you can file a better application. If you want to file any other application.
May I submit something? My lord, the case is going on in Denkanar. Divorce. It was going to be over by 17th because final argument is there. Now already the family court Denkan already awarded 4,000 as maintenance to the opposite party. Now what my submission is that we may file a petition under section 127 of CRPC. So, looking that, this order can be passed to Deccan, right?
No.
That's it.
No. Since you submit that the case which you wanted to transfer is no longer available, the transfer application becomes infructuous. It is open to you file another application, doesn't matter. It will not stop you from filing.
Because out of that,
It is submitted by land counsel with the petitioner that the case sought to be transferred. That is CRL, the criminal miscase number 92 of 2023. In the court of learned decision Tarcher has already been disposed of. The transfer is rendered infructuous and is disposed of as such.
31.
31, yes. For which corner? The opposite party applicant.
One chapter.
Hey,
I am challenging, I am filing this petition, transfer the CRP petition 22 by 2024.
notice has not been issued.
Yes, notice issued.
File tell physical file tell. Yes, scan corona that is a big problem.
3rd July.
ऑर्डर शीट में स्कैन करना है इधर ऑर्डर कीजिए देखो देखो 3-7 ऑर्डर है बिल्कुल स्कैन ही नहीं
उसके तो 31st
directed to be listed on 31st. It was never listed.
No, but code did not function. Yes, code did not function.
Okay, code didn't function on that. Okay. So what do you want now?
1 week time. 1 week after.
No, I have notice was not issued.
Notice I already issued.
Okay, okay. What has happened to the notice?
Notice sufficient. ADS.
देखिए कौन सी condition जानी होगी? How do you know that notice has been sufficient?
ADS tagged.
ऑफिस नोट किसी करना था बुझे मन रहो ऑफिस ये देखो ये पटा स्कैन इन ऑफिस नोट है list this matter on 13 September as paid for adjournment.
32.
May President. Later notice was issued a lordship. The transfer application of present petitioner the wife held this transfer application for seeking transfer from the Lorraine Judge Court.
All right. Sri S.K. Bora, Lorraine Counsel with the petitioner is present. None appears for the opposite party. On the last occasion also there was no appearance from the opposite party. Transfer application allowed. Huh?
Obliged.
35.
33 ରେ
33 sir adjournment.
ଆସି ସକାଳୁ ଆର୍ଜନ କରିଥିଲେ
ନାଇଁ 33 ରେ କଣ ହେଇଛି advocate for the petitioner Rashmi Ranjan Das his son is hospitalized and he is attending his son ସେ ମତେ ରିକ୍ୱେଷ୍ଟ କରିଛନ୍ତି କି let it come 2 weeks after
ଆମର କେବେ ହେଇଛି
Next week.
2 weeks after कर दो ना तो डेट कर दो ना take it up on 6th September
my lord
all right
my lord
his associate probably will not know this date please inform him
I will inform my lord
yes
his son is undergoing treatment in MKCG hospital
that's all right
35.
I am for the petitioner, my lord, sir. Notice was issued, opposite party, my lord, appear, my lord.
appear
And no counter has been filed.
counter कौन हुई थी
And they have asked for counter, my lord.
Sri D.K. Ponda, Lorraine Counsel for the petitioner is present. None appears for the place this matter next week. So next week, if he doesn't appear, then
Interim order to
continue. That is the method. One opportunity will be given. If he doesn't appear, then yes.
36.
Yes.
That's if I am appearing for the opposite party.
Can we take up the matter next week?
This was directed to for mediation.
Mediation fail ହେଇଗଲା sir.
The
am
report of the
deeply-
mediator indicates that the mediation between the parties has become unsuccessful. You want some time? Learned counsel for the requests for an adjournment. Place this matter on 13th September, interim order to continue. 13th September or कौन? Interim order तो अच्छी थी बस तो कौन?
37.
Judge has the last word.
हाँ. Judge जा बुझिले सा law. Judge जा बुझिले जा सेटा law.
ମୁଁ ମନା କଲି sir.
इटे बंद कर. Mr. Satpathy, what is this?
37.
Mr. Satpathy, what is this?
37.
What is this?
Sir, ସେଥିରେ interim order ଟା ଥିଲା.
No, interim order is.
Today,
You are appearing.
my lord.
Mr. Bahadur enters appearance for the Mr. S. Bahadur, sorry.
Not BB Behra name reflected. And he is the
ମୁଁ ଯାହାକୁ ଦେଖିଲି ଆଜ୍ଞା କରିବି. Court has power to କଣ ସେଟା provision କେତେ? କେତେ provision? Court can appoint anybody to conduct the case. Not amicus curiae. Not amicus curiae. ଆଉ କଣ provision ଅଛି କି?
ମୁଁ ଜାଣି
I think Mr. Das will know. Order 2, no, order 3. Court can appoint anybody. Just for our academic purpose, let us know. Brush up our knowledge whether we are right or not. Order 3, Rule 4. ये नौनाथी ଏଇଠି ଅଛି ସାର୍ ଅଛି ये 4 is general. This is a provision.
Provision for?
But the court can appoint anybody to
conduct case.
Anyway, the BB Behra advocate and associates have entered appearance for the opposite party. Yes, are you ready?
My learned family directed to Kosa have a copy, my lord.
Why have you not received a copy?
No, copy not received, my lord.
The Wakala be kept on record, their names be reflected in the
I have served the copy on the State Council.
You serve another copy, Mr. Smile. Let a copy of the transfer application is served on the other side. List this matter. Any chance of settlement?
No, my lord.
I have challenged the validity of the marriage. Of settlement कौन?
List this matter on 30th August.
अरे 5 को डेट अच्छी तब पर एक डेट
13th September.
मतलब
13th September.
38.
कॉपी टा को आज देवी in course of the day.
I don't know.
हम देख.
38.
Already filed, madam. Today morning I have because of clerical mistake, they all the right.
Requisites file be accepted and notice be issued as directed. Fixing a short returnable date.
Interim order to continue.
List this matter on 20th September. Interim order to continue.
Okay.
39.
Well, appearing.
Miller, please. Put between daughter and father. Let
Daughter and father कौन हुई थी?
The adoption maintenance.
Adoption,
Maintenance.
maintenance.
The daughter is educated, serving.
Not for being. Has been.
ବାପାଙ୍କୁ ପଚାରୁନାହାନ୍ତି ଆପଣ?
ଆଜ୍ଞା
ବାପାଙ୍କୁ ପଚାରୁନାହାନ୍ତି?
just ଉଲ୍ଟାଟା ବାପା ବାହାଘର ପାଇଁ ଖର୍ଚ୍ଚ ଏବଂ ତା ପାଇଁ ସଷ୍ଟେନାନ୍ସ ପାଇଁ ଦଉନାହାନ୍ତି ବୋଲି ରିଟାୟାର୍ଡ ଏମ୍ପ୍ଲୟି
Have a settlement.
ଆଜ୍ଞା
Mr. Naik,
ସେଇଆ ଭାବୁଛି
have a settlement.
ହଉଯାଉ ଯଦି
Both parties are at Raurkela.
ଆଜ୍ଞା
Residing at Palazzo.
And the girl is staying at?
ରାଉରକେଲା
So we'll have the mediation here at.
that is my
Alright.
my lord humble sanction.
Since the dispute is between father and daughter, it is stated at the bar that the same can be resolved amicably. Same can be attempted to be resolved amicably through the process of mediation. Mediation or what High Court Mediation Center. Let's this matter on 20th September, no, 27th September, interim order to control. These matters, adjudication over settle. I'm sending a lot of matters to mediation. Some of them are being settled, not all. Most of them are returning unsuccessful. Still, that attempt must be made. What will happen is, after some days, there will be a culture of mediation. You will see, maybe in our lifetime also we will see. The next generation will see it more. There will be mode of adjudication, will not adjudication, resolution of disputes will be through mediation. Mediation or any other alternative dispute resolution.
Alternate dispute.
Yes, item 40.
27 September.
Item 40.
They will be noticed and they will.
That same order will be there.
Format is there. They will be noticed and they will appear.
Yes, yes. Yes, Mr. Das.
Notice has gone, but it is not returned. At Club B, the postal track recording. At Club B, may I invite your kind attention to Club B.
E3 भी नहीं, ये फाइल टेक बार करो, ये फाइल टेक बार करो. CPC को रखे चल. हाँ, लोकल, इधर स्कैनिंग. कौन करे? कौन ही? इधर ऑर्डर तक कौन है? ये पेपरलेस करेगी लाभों को. Postal tracking report enclosed to the case record shows that the notice has already been delivered on the opposite party. There is, however, no appearance. One more opportunity. Now, let's this matter on 13th September to enable in order to grant one more opportunity to the opposite party to appear. Let's this matter on 13th September. Yes.
Any interim or
It's
Oblak.
41.
That examination of A and B matter.
Oh, that matter, yes. No, you are on bail.
I am on bail, but
not
last date was 7/8. Same.
Last reason, interim bail extended for 3 weeks.
And there is no application for cancellation of bail has been filed. Cancellation of interim bail has been filed by the prosecution, which suggests that he has not misused his liberty.
I have not misused the liberty, and well, they have kept.
He will remain on bail. What is that?
They have kept. My lord was pleased to reject my application 2 years back because of this A and B. My lord, one prayer, my lord. A and B will be examined, it's well and good. Otherwise, there should be an exemplary cost. A teacher, my repeated submission was, he's a teacher and a toy walkie-talkie was found. But because of AB and my lord expressed my lord feelings, they know AB.
Because whatever was there in that
Yes.
confidential.
And that A and B, whether that has been created by them. And till date, but just 8 dates they have already taken. Let them out 2, 3 dates out. Cost lead this IO to ladder nation. They cannot.
I'll pass
Something.
I'll pass an order. Cost and bail applications.
Not bail application. The action. Why, my lord, in between date is there, lower court.
No, let me pass that order. Sri D.P. Dhalal and senior counsel submits that the witnesses named Mr. A and Mr. B have not been examined as yet. He therefore prays that the interim bail be further granted to the petitioner be further extended. Stop. Learned State Counsel is unable to explain as to why the above named have not been examined for so long. Stop. Having regard to the fact that the prosecution is taking inordinate, prosecution is has been delaying the examination of the two witnesses,
Namely AB.
named Mr. A and B, without any valid reason. This court is inclined to extend the period of interim bail by interim bail granted to the petitioner by a further period of 4 weeks. Further, the court below is directed to take note of the delay in examination, a delay in conclusion of the trial, and to pass necessary orders for early conclusion, if necessary by passing appropriate orders in the matter. Lays this matter on 4 weeks बने ता परे के भाव
Malad is extending for 4 weeks please approved again.
4 weeks हेले मन आज हेला धरो 9 हेले
September Malad
we'll take it up on 4th September.
4th September.
This matter on 4th September. Necessary already once interim bail has been granted, once it has been extended, and now again it has been extended.
I will also take it.
So you take instructions.
And the case is posted to Malad 17/8.
17/8 और ता भीतर पड़ जाउछ अपन. So whatever you see that a criminal case is like a sword hanging over the head. Not me, but the Supreme Court has held in many cases. So
Democracy sword.
whatever Democracy sword. So you want to examine, you examine. If you want to, if there is material convict him, he can be convicted. The court will convict. Otherwise, he will be acquitted. But A type of Mr. A and B, इतने confidentiality को रखी की maintain करेगी कि क्यों?
I will also take is not found, Malad, that too, at least minimum procedure which is being taken usually by the courts below, trial courts, issuing bailable warrant or nothing is there, the record, till then.
The court is also taking, that is why I passed some order, so that the court will, then thereafter we'll see.
Well,
Item 42.
42. After order of this, the present person already surrender before the law and surrender certificate already filed, my lord.
Okay.
Also copies supply my government.
Surrender तो कर ले अपन को. Surrender कर ले अपन.
Surrender in time.
Surrender कर तो कौन है इसमें? मतलब you have surrender.
No eyewitness to the occurrence, my lord. The kiye कोउतरा assault कला मनोरमा रेखा तो eyewitness. माउ भाउज ଆଉ 28/5/2021 ର କେସ୍ କାଉଣ୍ଟର କେସ୍
Release this matter 1 week after. ଏବେ ଆସି ଯାଇକି ଆସିଛନ୍ତି ପୁଣି ସାଙ୍ଗେ ସାଙ୍ଗେ ବେଲ୍.
ନହେଲେ ହଜୁର ଇଣ୍ଟରମିଡିଏଟ୍ ବେଲ୍ ଟା
ସେଇ ଇଣ୍ଟରିମ୍ ବେଲ୍ କଥା କହୁଛି ଏବେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇକି ଆସିଛନ୍ତି ଆଉ
ରେଗୁଲାର ବେଲ୍ ଟା
1 month then extended for 6 weeks.
ମୁଁ ଯାହା ଦେଖି ସାରିଲିଣି ସେଇଥିପାଇଁ କହୁଛି. ମୁଁ ନ ଦେଖିକି କଣ କହୁଛି ବୋଲି ଆପଣ ଭାବୁଛନ୍ତି ମୁଁ ଦେଖିଲା ଯାହା ଦେଖିବା କଥା ଦେଖି ସାରିଛି. ଏବଂ ଯାହା ବୁଝିବା କଥା ବି ବୁଝିଗଲେଣି ଏବଂ ଯାହା ଅର୍ଡର ପାସ୍ କରିବା କଥା ବି କରିସାରିଲେଣି 1 week after.
43.
Modification of order, madam.
What modification?
In respect to the petition note 5, her name has been wrongly reflected as Sumitra Sahu
In the cause title.
instead of Sumitra Patra.
In the cause title though.
Post title.
Learned counsel for the petitioner is permitted to correct the cause title, correct the name of the petitioner number 5 appearing in the cause title in the office. You cannot do it here in the office. 2 weeks for the time.
Extension of time.
2 weeks for the time.
Okay.
Yes, this is the first time. All right, 2 weeks time.
Oh, bless you.
46.
Permitted to withdraw. IA permitted to withdraw. Yeah. Sorry. Enough. 48 ಆಗಲ್ಲ. 40 ಅಲ್ಲ?
46.
Order be corrected appropriately.
47.
47, the matter has become infructuous. The petitioner acquitted on
Dismissed as infructuous.
the
48.
Item 48.
Yes, Mr. Rai.
Petitioner is the husband. 304B case, my lords has directed me to file the depositions. I was unable to collect those depositions, my lord.
One time.
Friday, so otherwise your lordship may give him some interim bail because since 3 years he is in custody. There is no
Deposition देखिए था.
then again. Next Thursday,
If I do that, I will be recalling my own order. Why should I do that? You produce the depositions, I'll see.
I'll pay.
Sri Rai Learned Counsel for the petitioner requests for some time to produce the depositions of the witnesses examined in the ongoing trial. Is this matter when do you want?
Next Thursday or Friday.
No, we'll take it up on 23rd. You may not be able to keep.
नहीं मो पे 5टा আছে और 2টা আছে
Okay, on 16th?
16th, yes.
16th. 16th August.
49.
Please. My lord, case under section 307 along with other allied offences, my lord. 323, 325, 506.
Earlier rejected.
My lord. Due to previous dispute, my lord, between the injured and the present petitioner, the petitioner assaulted the injured. My lord, total, my lord, 7 injuries. All are laceration and simple. And the petitioner is now, the petitioner was arrested on 15/9/2023. And charge sheet has been submitted on 26th. Looking into the manner of assault, lordship has been pleased to reject the application. Now he is inside custody 307. My lord.
Yes.
Fracture, apart from that 7 injury, fracture is also there.
No, fracture good nahi.
अच्छी ना थोड़े X-ray देखना. Hand fracture of third it reported by the radiologist and opinion regarding the nature of injury to the eye, face.
What is the status of trial?
Commitment है.
So we do declare.
This
Yes.
was a statement that axe also was seized from the present petitioner, my lord.
Due to previous dispute,
The petitioner is in custody since 15/9/2023 in connection with such and such case. Stop. His earlier application for bail was rejected by this court. As per order passed in BL appeal number 13557 of 2023. The present application has been filed. As in the meantime, the case has been committed to the Court of Sessions. Stop. Sri Mishra Learned Counsel for the petitioner submits that the charge was framed in this case way back on.
Charge was framed. I don't
कोई लिखना डेटा कोई लिखना
know. Commitment date टा कहले.
केबे
Commitment ହେଇଛି 22/24.
on 20 नहीं सर लिखो
Commitment टा ହେଲା 22/24 ରେ. Charge sheet ହେଲା 26/10, commitment ହେଲା
It
20.
is submitted that the case was committed on 22/2024, but charge has not been framed as yet. Looking at the delay in conclusion of the trial, that the petitioner should be released on bail. Para. Sri S.K. Mishra Learned Additional Standing Counsel has opposed the prayer for bail by submitting that there is clear evidence that the petitioner assaulted the deceased with the intention of assaulted the injured with the intention of killing him. Stop. This court finds that though several injuries were sustained by the injured, yet most of them, almost all of them are simple in nature. That apart, the petitioner has been in custody for nearly a year and trial is yet to commence, despite the case being committed to the Court of Session. Yeah. Taking all the facts into consideration, I am inclined to let the petitioner be released each day appearance.
50.
Pass over.
May I permit, sir? Sir, item 50, sir.
All right. Item 50, take on. Item 50, yes.
Lordship, here the offense is 302, Lordship. Here in this case, Lordship, all the accused persons already enlarged on bail by the order of this court, Lordship. And I have annexed the annexure, the extract order passed by.
Does he stand on the same as this Akash Patra?
Jabbar Khan and
Akash Patra?
Akash Patra is in different, he only intimated regarding the
So this Jabbar Khan kai?
Jabbar Khan, page 45 and page 47, Ajit Sanda.
Page 45. Huh? Same order.
Yes.
Yes, Mr. Sahu.
And
Item
Pintu
50.
Bahadur, three cockets.
Again?
Pintu Bahadur, Adjournment, he has been released on the same.
They have
Yes.
307. They have approached this honorable court. Your lordship directed first or second. Again, I have moved, my lord. Parity nahi, first or second parity kali ହେଇଥିଲା ଗୋଟେ check କରିଦିଅ ତ
Modification report କେବେ file କଲେଣି?
ସେଟା ମୁଁ power ନାହିଁ ସେଥିରେ
କଣ ହେଲା ସେଠୁ? Disposal of case ରେ you can file a modification application. ସବୁ case ରେ ସେ କରୁଛି କାହିଁକି why will we break that? I'll just keep adjourned to next week. ସେ case ରେ file କରନ୍ତୁ ଏଟାକୁ withdraw କରିଦେବ.
ଆଜ୍ଞା oblige
Next week as spread for.
52.
Item 52, my lord. My lord, this is a petition for extension of time, my lord.
52, yes.
This is a petition for extension of time to surrender, my lord.
Okay, 2 weeks time.
Oblige, my lord.
53.
53.
may I please lordship I granted bail some co-accused, my lord, in the same footing.
Pradeep Raut alias Deepak Raut.
Oblige.
What do you say?
Similar matter.
Same order.
Could not prove the assault.
All right. Same order.
54.
May I plead your lordship annexed to running page 13 in the co-accused anti-suitor bail. I am in better footing. Mo na FIR na.
Ramandra.
Better footing.
302 along with 3 SCST.
Pramod Rai. Pramod Rai से जो 302 order था ये तो अच्छी होती
Co-accused को annexed 2 रे दिया है annexed.
Same.
55.
May I please your lordship, interlocutory application wide.
The order be corrected accordingly. Appropriately. ते रकम से नहीं से आसिले डाकी दिसन पास ओवर केतरा हिज डाकी दिन गोटे गोटे नउथबा तापर पास ओवर केते हिज
Pass over item 11. My lordship. My apologies when the not there. And here it is the case, my lords.
My apology that I should have dismissed it, but I have not dismissed it.
We are grateful, my.
I really am apologetic. Yes.
Here I have nothing more to say. The other day I was just canvassing my grievance.
Just briefly recapitulate, Mr. Das.
My lords.
Briefly recapitulate.
Yes, it is relating to an Anganwadi worker getting promotion to Anganwadi supervisor way back in 2010. In 2008, some Anganwadi workers were promoted to supervisors.
Oh, that contractual
with a
basis.
regular scale of
On
pay.
contractual basis. Oh, all right, I
In
remember.
2011, they were regular. I am in contract. Now, I had submitted one incorrect statement before this honorable court that I am supposed to retire in the month of October. No.
I have already retired in the month of March. Page 31 actually misled me. They have,
then Mr. Das, does any cause of action survive?
yes,
How?
because my lords, I have already approached your lordship since 2011 and 12. I have been harping my grievance before the authorities, and this honorable court took cognizance of that I should have been given the benefits. My employer, the appointing authority, decided hence, and the rest was left with the government, who did not take any decision. Now, my equal pay, equal work, I may not be treated to be a regularized employee after my retirement, but with relating to my scale of pay or the emoluments that I am entitled to pay, that can be taken note of by your lordships. And that has been settled by Honorable Supreme Court, that I have to.
Today I have passed a judgment. Today, one of the judgments is the person was officiate in a particular
Yes.
with a higher post,
Yes.
and he retired in that for after serving for 16 years. He was never promoted. I said, if you are not promoted, don't promote him, give him his scale.
Yes, ma'am.
Minus whatever has been given, of course.
Yes, yes.
Along with pay revisions and everything, so that his
Yes.
last pay drawn will be fixed accordingly and he'll be entitled to pension. But here, you are not entitled to pensionary benefits?
No, but my service, my salary components, I'm entitled to.
Yes, certainly. Yes, what do you say?
Annexer E by 3 to the counter affidavit. He has undertaken that he will not claim all these.
That undertaking has got no meaning. Is that also I have recently?
That is what the
Yes.
counter says.
I have referred to a judgment of the Supreme Court saying that where a person is in a dominant position to
Yes.
this undertaking has got no meaning.
Yes.
And certainly a court of equity will never deal with it. At least a constitutional court will never look at it.
Yes.
And that is an unenforceable contract.
It is an unenforceable a contract which
Cannot be
the
sustained
person has
with law.
signed against his own interest.
Yes.
That cannot be considered. Equality thile abo.
Yes.
In a commercial, the Supreme Court has highlighted where such a contract can be accepted, where the parties are on a level playing field. Here, obviously, they are not on a level playing field. One is the mighty employer, the mighty government, and a poor Anganwadi worker or supervisor, whatever.
And discrimination is telltale.
So, where is the previous order of this court?
Well,
The previous order of this court you were referring to, some order by this court?
yes, you have directed consideration of my case, right? Annexer.
Let us see how it was considered. Let's see the impute order, which is
I
Annexer
take
11.
To Annexer 11, page 43.
Achha.
That is the order of the collector dated 21st of March 2013.
Yeah, but this order is in your favor, I believe.
Yes, my lord. But only last line.
Directed to the obtained clarification from
government to
government.
get a clarification, and they never got a clarification, and I was made to retire. The collector did enough to find.
We will dispose it of here today, right now. We'll dispose it of.
I will be grateful, madam.
What order can be passed finally? We'll say that this order will refer to the order of the collector, saying that the collector has found that she is eligible for promotion.
What clarification was?
But in the meantime, since she has retired, so there is no question of granting that relief. But at least she'll be entitled to the pay that is available to the promotional post. What do you say, Mr. Das? That is the only thing that you will get.
I'm grateful, my lord. That one. And my appointment order, your lordship sees page 64, Annexer F by 3. That is 1st of June 2010.
The judgment are not in issue. Supreme Court judgment refer refer
Supreme Court judgment board re notes of submission I have enclosed. Yes.
Okay. Regarding this contract,
Yeah.
note टा तो आपन read petition to board ना तो पढ़ियो की and you expect the court to read those things.
Yeah, see you out of ignorance write everything that may come your way.
That I will not say.
That is 2017
ILR cutter.
ILR cutter. That is one of state of Punjab and others versus the senior professional staff members.
And I can correct it later.
Yes. And your lordships have been also pleased to decide one more case in that Gopavandhu Biswal's case, Odisha Mining Corporation case. Pursuant to your lordships, the state government is competent to rectify their work if it is found at any point of time.
All right. The petitioner was not okay. The petitioner was appointed as Anganwadi worker under ICDS project Binjarpur in the year 1983 by the CDP of Binjar. While working as such, in the year 2007, the government formulated a policy to promote graduate Anganwadi workers to the post of supervisors, having regard to their seniority. Since the petitioner was a graduate Anganwadi worker, the District Social Welfare Officer Jajpur, bracket OP number 3, directed dated 30/4/2008 to the petitioner along with some other Anganwadi workers to appear before a subcommittee on 3/5/2008 in the office of Sub-Collector Jajpur for the purpose of assessment of their suitability for promotion to the junior grade service. Pursuant to such direction, the petitioner appeared, petitioner and others, out of whom 10 persons were promoted to the post of supervisor by order dated 16/9/2008. Being granted the scale of pay rupees 4750-125-7500. Please correct me if there is any wrong facts. All right, Mr. Das. Subsequently, the Government and Women and Child Development Department issued a clarification regarding filling up of the post of Anganwadi supervisors by graduate Anganwadi workers who have completed 7 years of continuous service.
Well, that would be 5 years.
5 years to wait. 5 years. Actually 5 years, ଦେଖିଲା 7 ହେଇଗଲା. ଆପଣ ଠିଆ ହେଲେ ଭୁଲି ଯାଉଛି କଣ କରିବେ? ହଁ ବସ ପଡ. Accordingly, a gradation list of Anganwadi workers, of such Anganwadi workers, was prepared for the district of Jajpur on 29/7/2009 and was for necessary action. The name of the petitioner appeared at serial number 1 among 43 candidates. 43 लिखा है. Out of the said list, the top 18 candidates were shortlisted on the basis of their seniority and objections were invited. Ultimately, the government decided to appoint such graduate Anganwadi workers as ICDS supervisors by order dated 1/6/2010 passed by the DSWO Jajpur. The petitioner was accordingly relieved from her post on 4/6/2010 so as to join as lady supervisor in ICDS. However, the petitioner was paid consolidated salary of rupees 9,300 only, whereas the other ICDS supervisors were granted a higher scale. Subsequently also, nine more Anganwadi workers were promoted to the supervisor in the scale of rupees 9,300 to rupees 34800 with grade pay of rupees 4,200. Stop. Significantly, they were non-graduates, and three of them were junior to the petitioner. Approached this court in WPC number 22017 of 2012. Stop. This court, by order dated 22/11/2012, directed the opposite party number 2K collector Is it the collector?
Yes, ma'am. Collector.
The collector Jajpur to examine the case of the petitioner and to take a decision strictly in accordance with the merit of the representation after affording opportunity of personal hearing. Stop. Pursuant to such order, the petitioner submitted a fresh representation on 4/12/2012 before the collector. Stop. The collector, after hearing the petitioner, passed order on 21/3/2013 accepting in principle the of the petitioner, but directed the DSWO to obtain clarification of the government regarding eligibility of the Anganwadi workers appointed on contractual basis in the post of ICDS supervisors for promotion to the said post under the existing rules and of the petitioner.
Beg your pardon. Your lordship may indicate that is the collector order says promoted. And appointed let it be, let that what will come out. That is case 46 of your lordship's brief.
No. What did I write? Last part this
appointed as Anganwadi supervisor.
No. That is what he has got. Regarding the eligibility of the Anganwadi workers appointed as contractual basis, selection.
Selection promoted.
No. तापर election promoted. तापर election. से ठीक लिखा है. ठीक है. Being aggrieved, the petitioner has approached this court with the following prayer. Counter affidavit has been filed on behalf of the state opposite party numbers 2 and 3. It is inter alia stated that while the facts period in the writ application have not been generally disputed, it is stated that the petitioner exercised her option and submitted her consent for the post of supervisor on contractual basis with an undertaking that she will not claim regular status. Stop. As such, her subsequent claim for regular status is not tenable. Basically,
Sir,
this is basically our
main.
This is the main problem.
In the counter.
That's all. The petitioner has filed a rejoinder to the counter. refuting the averments therein. Stop. It is stated that the Odisha Children and Women's Welfare Service Rules 1989, as amended in 2007, does not postulate contractual engagement, but provides that the posts in the junior grade shall be filled up by allotting 30% of the total number of vacancies. Category recruitment and the remaining vacancies to be filled up by way of promotion as per Rule 8 from amongst the Anganwadi workers of the district and lady village level workers. There is no provision for making any contractual appointment. Do you have that rules? Yes. Keep it ready. Please keep the relevant provisions ready. It is further stated that the furnishing of undertaking by the petitioner cannot be treated as a bar for her for her legitimate claim of being appointed on regular basis. Stop. Heard Sri S.S. Das, learned counsel for the petitioner, and Sri A.R. Das, learned AGA for the state. Para. Sri Das would argue that the so-called undertaking given by the petitioner at the time of her joining as ICDS supervisor can have no sanctity of law, has no sanctity, as the employer being in a dominant position, such undertaking is automatically rendered an unenforceable contract. Stop. Sri Das further argues that the rules do not provide for any contractual appointment. So, the mode of appointment as per the rules is either by direct recruitment or promotion. Moreover, persons junior to the petitioner and also similarly placed as her granted the regular scale, which amounts to discrimination. Stop. Sri A.R. Das, on the other hand, submits that. Sri Das finally argues that the collector, while disposing of the representation, has accepted the genuineness of the claim of the petitioner, but stopped short of issuing necessary directions. Sri A.R. Das would argue that the petitioner herself submitted an option not to claim regular appointment, for which she cannot turn around subsequently and make such a claim. So, that's all, Mr. Das?
Yes.
Yes. This court finds that the facts of the case are not disputed. There is also no gradation list. The petitioner was placed at serial number 1. Stop. 18 persons were appointed as ICDS supervisors. There is no reason. The rules টা পড়ান সেই বইরে ଅଛି অঙ্গনওয়াড়ি বই তো কেতে পেজ কোন
Page 14. Page 12, there are rule 6, page,
The Odisha children's and women's rule,
page 16 rule 8.
Is relevant for the purpose. Rule 6 provides the method of recruitment to junior grade of service, which includes the post of supervisor, and is quoted here in below. Quote kar do. Insofar as promotion is concerned, Rule 8 is relevant. And their reading of these provisions makes it abundantly clear that there is no provision for any contractual engagement, a contractual appointment of ICDS supervisors, either by way of direct recruitment or by promotion. In fact, the collector, after considering the facts of the case and the rules, has inter alia held page 45 ru जो second paragraph ta achi सेटू नहीं जाता. In view of such finding of the collector and the provisions made in the rules referred above, this court has no doubt that the petitioner ought to have been promoted as ICDS supervisor on regular basis. There is no plausible explanation forthcoming from the side of the state for engaging the petitioner on contractual basis and thereby paying her salary less than what she would have been entitled to had she been promoted on regular basis. Stop. Yes, Mr. Das.
Your lordship's leave. Your lordship note of annexer 12 also. That is with the flag a additional affidavit. Annexer 12, that other day your lordship finding that the post against which the petitioner was appointed was a created post in 1997.
Further, this court also finds that the post of supervisor was created by the government on regular basis as per order dated 17/2/1997 of the government in WCD department, a copy of which has been enclosed as Annexure 12 to the additional affidavit filed by the petitioner. Stop. There is thus no reason for the petitioner being appointed on contractual basis. Stop. This is being said for all the more reason was bound by the undertaking her, this court holds that the same does not carry much water, inasmuch as it is well settled that an undertaking submitted by a party against his own interest can have no sanctity in law. Stop. Moreover, if such undertaking is obtained by the employer, who is in a dominant position, the same reference in this regard may be had to the judgments of the Supreme Court in such and such case. It is stated at the bar that the petitioner has in the meantime retired on attaining the age of superannuation. Therefore, having held as above, this court, the only relief that can be granted at this stage to the petitioner is directing the concerned authorities to pay her the regular scale of the post from the date she held the same till the date of her retirement. Stop. In other words, the petitioner should be paid the differential amount of the salary attached to the post of ICDS supervisor for the above period. The writ application is therefore allowed, is disposed of, directing. Who will be directed? Collector.
No, the opposite party number 1 and 2.
Directing the opposite party numbers 1 and 2 to pass necessary orders to grant regular salary to the petitioner in the scale of rupees 9300 hyphen rupees 34800 with grade pay of rupees 4200
No, that is
with all subsequent pay revisions as may have occurred till the date of her retirement. Such payment shall obviously be made by deducting the amount already paid to her towards contractual remuneration. Since the petitioner has already retired, necessary orders shall be passed within a period of 2 months from the date of production of certified copy of this order by the petitioner. That's all. Anything else?
great.
Any factual error?
If not, 43, your lordship insisted, and I also have committed an error, but the record says it is 44. That is at pay annexer 5, page 29.
44 persons.
Yes.
We'll make it
43.
44. That's all?
No.
What do you want?
For a short adjournment next week, madam.
Item 14 next week as per.
23rd let's make BC रे देखा लूंगा आसिले
अच्छा next week as per.
17
None appears disposed of. Will dispose of.
18
Disposed of.
26.
26, my lord. After the matter was called, my lord, thereafter the non-counsel came. In this case, my lord, on the last occasion, I had taken the time that the otherwise comment which I had received, that was not sufficient. And today, my lord, actually this is a letter dated 8/8, but today the person himself physically he has come and he has handed over a detailed otherwise comment along with all this. So may I pray, my lord, only one with time back so that I can.
Sri S.N. Patnaik, Learned AG submits that he has received the complete parawise comments along with the documents today and requests for some time to prepare the counter affidavit. There is this matter on 30th August.
Yes.
Counter affidavit, if any, be filed in the meantime. If any, counter affidavit be filed in the meantime. Yes.
We can pass over.
अब नहीं सरियल है सप्लीमेंट्री सरियल है वीकली का
Weekly list. Pass over item 2.
এটা বন্ধ করো করো খোলো লিস্ট খোলো
ସାର୍ ଆଜି ବି ମୁଁ କହିଥିଲି ବାର୍ତ୍ତାବାର ସାର୍
ଆସି ନ ଆସିଲେ
ସେଇ କଥା ମତେ କହିଲେ
ସେ ଦେଇଛନ୍ତି ରିଟର୍ନ ନୋଟ ଟୁ
ଗୋଟେ ଦେଇଛନ୍ତି
ଆପଣ କପି ପାଇଛନ୍ତି
ଆଜ୍ଞା ହଁ କପି ମୁଁ receive
ତାହେଲେ ହେଲା ଡୁ ୟୁ ହାଭ୍ ଟୁ ସେ ଏନିଥିଙ୍ଗ ଛାଡ଼ ଛାଡ଼ ଡୁ ୟୁ ହାଭ୍ ଟୁ ସେ ଏନିଥିଙ୍ଗ
ଆଜ୍ଞା
ଆଉ ଟିକେ ଖାଲି ଜଷ୍ଟ ବ୍ରିଫଲି ରିକ୍ୟାପଚୁଲେଟ୍ କରିଦବା ତାପରେ ଆଇ କ୍ଲୋଜ ଇଟ୍
ସେ ଗୋଟେ ଆଏ ଫାଇଲ ଗୋଟେ ନୋଟ ଅଫ ସବମିଶନ ସେଥିରେ ଅଛି
earlier had filed अच्छा हाँ अच्छा अच्छा yes sir
paragraph 3 देखो
paragraph 3
the defendant number 1 and 2 contested and observed by taking their pleas in their written statement mainly that the suit is non-joinder of necessary parties because the suit properties are the joint and undivided joint family properties of the Abhimanyu Behera along with his sisters and others. इथरे मु देछि आर पत्र गुटे अछि देखो नेक्स्ट पेज रे गुटे जजमेंट भी साइट करछि that suit cannot be page 4 page 4
non-joinder of necessary
like
party
it is submitted that the distribution cannot be made behind the back of some recorded tenants इथरे कोन हेछि से आइवान बेरा तांकर कोसेरर मानको पार्टी करला तेणु behind the back of the person's interest suit was filed which is not maintainable and सेत्र मु देछि जजमेंट 22 2022 SCC online Supreme Court 1307 if a necessary party is not included, the suit itself is liable to be dismissed.
what was the suit for declaration
Judgment copy deeds.
suit was for declaration
Right?
suit was for declaration all right then who were not parties who according to you should have been parties
The other co-signers of Ivan. Paragraph 4. Further case of the defendant is that Arjun Behera was the owner of the suit property. Arjun died leaving behind him his 4 children, Abhimanyu, Draupadi, Almoni, and Asal. The that part, the suit property is under Exhibit B is recorded joint family property jointly in the name of all the aforesaid 4 children of Abhimanyu along with Jotari and Bhimo. ସେଥିରେ କେବଳ ଅଭିମନ୍ୟୁ ଇଏ କରିଛି ତେଣୁ behind the back of others it cannot be copy ଦେଇଛି
yes then
page 3. Subpara. On that ground, the trial court dismissed the suit of the plaintiff for non-implementation of the necessary party. But the first set aside the same by giving observation in paragraph 12 that no doubt the suit land along with other land have been recorded jointly in the Hall ROR, but as per the oral evidence of defendant number 1 and 2, the suit properties along with other properties were partitioned between Abhimanyu and his sisters, and the suit properties had fallen in the share of Abhimanyu, for which Abhimanyu has rightly sold the suit properties. Therefore, the first appellate court decreed the suit of the aside the judgment and decree of the trial court. Next paragraph. The aforesaid observation of the first appellate court is not correct because it is the observation of the first appellate court on the basis of the evidence of DW1 that the suit properties were partitioned amicably between Abhimanyu and his sisters, that is Draupadi and Ansal. But there is no observation about the partition of the same with other shareholders, that is Jatri, Bhima and Almoni. There is no observation about in the meets and bounds between the recorded tenants. Plaintiff himself has admitted in paragraph 4 and 6 of his deposition evidence that the suit property has not been distributed among the recorded tenants, and they were combinedly having 16 decimals of land, which the trial court has observed at the end of paragraph 6 of its judgment. It is submitted that the distribution cannot be made behind the back of some other recorded tenants. That is what I was. City would a decision on 2022 SCC online page Supreme Court 1307. If a necessary party is not included, the suit itself liable to be dismissed. So copying file judgment copying. So 9, paragraph 9. 2024 to 2013 SCC online, Bombay 1141. Plaintiff and defendant number 1 had purchased an undivided interest of the co-personers in the joint family property, and the said property being undivided, none of the parties have acquired title to any definite share in the property as claimed. Therefore, order under challenge passed by the district court, setting aside the order of restraint passed by the trial court, doesn't call for any interference. Paragraph 12 and 13 of the judgment. Next page, paragraph 5, I have cited another judgment of 1971, Calcutta 252. It has been held at paragraph 9 of the judgment. In a suit for declaration of title and recovery of possession, all the co-owners are necessary parties to for non-joiner of necessary parties. Such a suit becomes incompetence. 65 Supreme Court 271.
Is that not necessary? Non-joiner of necessary party though. That is the only ground.
Again?
That was the only ground.
Yes, main ground, that is the main ground. That behind the back of others, it cannot be.
Well, then I'm closing it.
Again?
I'm closing it.
Again.
Hearing concluded, judgment reserved. You need not file your note. You have already filed your note. That's all.
I have already filed a note along with the note.
I've seen the documents.
And he has also submitted one.
Document judgment note. प्रयास करो अच्छी फाइल बाहर करी जो नथिबे तक मागिबे ऑल राइट सर यस नेक्स्ट आइटम सॉरी लिस्ट तो सॉरी खाली पासबुक रोड আছে দেখো 21 सीधा 21 21 Look up. None appears. Item 21, huh? None appears. On repeated calls. Release this matter in the week commencing 27th August. Taପରେ?
25. That I mean, see, the defendants are the appellant against a reversing judgment.
Mr. Sahu. Camera. Second appeal, I'm not sure.
And some difficulties of that.
Is the client not paying you? Order 41? No, order se achi.
Actually, I have this case for dispensing with the certified copy. In the meantime, we have submitted the certified.
You will take it up for admission.
Admission.
Yes, please.
That the defendants are the appellants.
So IA it are 619. No, IA 618.
Yes.
IA 618 has been filed in the meantime. The IA has become infructuous.
Yes.
The matter is taken up for admission. Yes. Yes, sir. What is
Defendant is the appellant against a reversing judgment.
reversing judgment? Yes.
Let the plaintiff file the suit for declaration of title and for confirmation of possession over the suit property. On the basis that the owner is that one Balabhadraswar Mahadev is the original owner and his father was the Marfather over, and the plaintiff, the defendant's name was wrongly recorded in the major settlement.
But the DT is not a party.
The DT is not the party. Why the DT has not been made as party? That they filed the suit, the defendant is the plaintiff. And the property was a part of the trust estate, and it was vested in 1965. After vesting, it was recorded in the name of the father of the plaintiff. And
the Marfather.
As a Marfather concept, after the vesting, he was not a Marfather. The property was recorded as a royal. He simply as a royal over the property. The DT name after the vesting, it is the property of the government. So therefore, because he was continuing in possession, so therefore the property was recorded in his name by acceptance of rent from that Marfather as the royal. As the royal over the property. And in 1966, he executed, of course, it is unregistered sale deed by selling out the property in favor of the father of the defendant. In 1966, under Exhibit N. Thereafter, the property was recorded in the major settlement record of right in the name of the father of the defendant. And he continued in possession. The trial court found that though we have taken the plea of adverse possession, our plea of adverse possession retired by a finding that he is in permissive possession over the property. However, it is found that the defendants are in possession over the property. Since the plaintiff has prayed for only declaration of the title and for permanent injunction, since he is not in possession over the property, unless he prayed for recovery of possession, the suit is not maintainable.
All right. So it was dismissed. It was dismissed.
It was dismissed. The suit was dismissed. That of the trial appellate court, by applying the procedure under Order 7, Rule 7, CPC, has said that even if he is not in possession, because the plaintiff is the owner of the property, so therefore the recovery of possession, the relief for recovery of possession is not necessary.
Section 34 was not referred to. Section 34 of the Specific Relief Act.
Section 34 of the Specific Relief Act, the trial court has referred to. The appellate court has not referred to. Appellate court only said, your lordship can see, only by referring to Order 7, Rule 7, they said that since they have prayed for the higher relief, so therefore the recovery of possession is not necessary.
All right, we'll admit it. Heard Sri N.K. Sahu, Learned Counsel for the petitioner, for the appellant. appellants को देखी दो ना, appellant की appellants देखी दो. Peruse the improved judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. It koribe page 10 ro 1 ta koribe, 3 ta koribe. 1 and 3 will do.
Yes, ma'am. 1 and 3.
Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Visits be filed within 3 working days. Call for the LCR. List this matter November. List this matter in the month of November. Thus,
For an interim order because he is
interim order achi.
disturbing my possession.
All right. Yeah, bol to kholo.
IA number 619.
619. Yes. IA 619. Status quo with regard to the suit property shall be maintained till the next date. Yes.
Lovely.
35.
The 2024 matter.
Yes.
How?
Fine.
How? Are you ready?
Ready.
Other side key.
For this a place admission matter.
It admission.
Yes.
Oh, I am sorry. No, I thought it was hearing matter.
Place admission.
Acha, acha. ठीक है, ताल सुन.
35.
Yes.
My lord, it is a confirming judgment.
Yes.
Confirming judgment.
Confirming judgment.
And both the courts below have with by referring to the pleadings that as if the claim was on the basis of adverse possession. So it becomes a question of fact where both the courts have concluded in one way. But here what has happened, you will also may kindly see, there were 2 brothers. The wife of the elder brother instituted the suit for declaring.
Actually, I had asked you to argue the matter. You had taken
That's
time.
true. But here it's a little bit that.
No, let her argue. Let her argue. Why are you stopping her? Let her argue. All young counsel are, I feel frightened by seeing senior counsel.
You will also may then keep it to Mondays.
हाँ, right now I remember. Yesterday I was not inclined to grant time. I granted time only on the ground that you should prepare and argue.
Yes, let her.
If there is any difficulty, your senior can always take over. But you should always attempt. Second appeal. Admission केमिति कराजिबो कोन हबो पढि के आसी आर्गु करंतु खाली टाइम नेले केमिति हबो. All such many junior counsel are doing. Yes. Next week.
Yes.
This is a matter next week.
40.
Don't worry, if there is any difficulty, the court will also help you. Don't worry. Item 40. In 2007, item of hearing. Huh? Item 40. Repeated calls. Though the matter was called out, the matter being in the weekly list has been called out every day. The appearance. Stop. The order sheet reveals that on the previous week also, there was no appearance. As such, it is presumed that the appellant is no longer interested to prosecute the appeal, which is therefore dismissed from prosecution. Yes.
42.
This is hearing.
Adjournment is there.
No, I don't have the entire record, so my difficulty lies there.
If you want to argue, you can start.
It is not with I can.
All right. As requested, let's this matter. We commencing 27th August. We commencing 27th. Yes.
44.
44.
Item 44, my lord. I pray next week, my lord.
Yes, as per.
Both the cases.
No, the original, the chairman from managing, I find an order passed by Honorable Justice Das.
They have similar since.
They are substituted.
Yes, yes, on that occasion also, Lordship.
We will grant one more opportunity. I'll say that there none has appeared, but it will be death faith ହେଇଛି ତ କଣ ହେଇଥିବ?
ସେଦିନ ବି କହିଲେ ଯେହେତୁ appear କରିଯାଇଛନ୍ତି ତାଙ୍କ ପୁଅ ସେଥିରେ probably doesn't reflect in the order.
No, the order passed by Honorable Justice Das says that it would be open to the learned counsel for the appellant to file formal application for putting the name of present chairman cum managing trustee of the managing trust in the cause title so as to proceed further. So they are not appearing.
They are not appearing.
ଗୋଟେ chance ଦବା ତାପରେ ଦେଖିବା. None appears for the appellant on repeated calls. Learned counsel Sri P.K. Jana is present. Learned counsel for the respondent Sri P.K. Jana is present. In order to grant one more opportunity to the appellant to appear, let's this matter in the week commencing 12th August. Are we dismiss kar do? No, I would have dismissed, but since there is death and some substitution has happened.
Only the managing trustee is there. Only name of the managing trustee in place of Dr. Balakrishnan.
So they have not taken any steps. What can be done?
Not
If they don't, then allow. Yes. Okay. Seven. The appearance of the initial date of possession, I take this with.
Then you will do or I'll do.
ପଢିଛନ୍ତି of law ଟିକେ this says I'll just place it. I'll just read it. Whether successfully proved their initial date of possession entry into the suit property and whether they are in continuous possession of the same throughout.
Substance ठीक frame ହେଇନି.
ये तो पूरा factual ହେଇଗଲା.
ଆଜ୍ଞା ମୁଁ ଦେଖୁଥିଲି କାଲି ରାତିରେ
It is purely factual here.
order dated 22/2/2022. I'll do one thing.
Give an additional substantial question. यही question टा ठीक हो. Purely factually used.
এটা কোর্ট নিজে ফ্রেম করে দিয়েছেন।
I will not comment anything, but I think
I'll give a better
because it may not lead to proper disposal of the Sri S.P. Mishra and senior counsel appearing for the appellants wants to file an additional wants to file a memo containing the additional substantial question of law, which according to him is required for proper adjudication of the appeal. Let's this matter next week. Let's this matter in the week commencing 12th August.
Okay.
Prepare, fully prepare, no half preparation. Yes.
52.
The respondent number 6.
Next week, Neta, for a week. Let's this matter in the week commencing 20th, 27th, 20th August. Tola. Tapre?
53.
53, it is to be hard on merit. It was previously hard, but the honorable judge has admitted the same. The substantial question of law has been framed. Now it is to be re-hard. So I am not fully prepared. Since there are 4 appeals, your lordship would
September? September, week as requested by learned counsel for the petitioner appellant. This matter in the week commencing 9th September.
will. Sir, ଟିକେ ଗୋଟେ 21ଟା ବୋଧେ
କରିବା admission ପାଇଁ ଅଛି ତ?
ନା ସେଟା ଅର୍ଡର୍ସ ମ୍ୟାଟରରେ ମୋର ମନା ନାହିଁ 27ରେ କରିବି। ସେ ଡିସିସନ ଗୁଡାକ ଟିକେ ଦେଇ ଦେଇଥାନ୍ତେ ନା ଆପଣ ସେଇଦିନ ଦେବେ।
ସେଇଦିନ ଦିଅନ୍ତୁ ବେଟର ହଜି ଆସିଯିବ କଣ ୟେସ୍
55.
your matter yes
Hi, sir. We have the respondent number 1 and
ठीक है Mr. Mahathi is there.
Yes.
Yesterday you were
Actually,
I'm not still fully recovered, but he's insisting so much. I will.
no what he will insist if you are not he will insist or what
No, yesterday.
not at the cost of your health Mr. Mahathi.
Even I'm
What is this?
able to.
The court will run according to me, not according to him. I made it very clear. He is himself a lawyer. Does he not understand?
1 week after I will do it.
Keep it pattern.
Yes, I will not go into the details of the facts. Here is a dispute between the landlord and tenant. The present appellant.
This is against you. Who are you?
Confirming defendant.
You are the defendant.
Some of the defendant, they are admittedly tenants.
Against the confirming judgment.
Confirm.
Take a seat.
Confirming judgment.
Yes.
So there is an agreement. This agreement for tenancy was executed on 2/9/2019. It is for 5 years. It is still in term is still continuing. In September, it will elapse. Now,
term is still continuing.
September, it will.
So 2019 रहता है. 5 वर्ष हो.
5 years. Now the dispute arose with regard to some payment, etc., with notice of this suit for eviction was initiated. During the plaintiff filed this that this agreement of tenancy 2/9/2019 at one point of time, these defendants were the appellants here. They forcibly entered into the premises of plaintiff, torn the original agreement into pieces, then handed over the torn pieces to the plaintiff, and after that, the torn pieces were joined together. The agreement was restored. Thereafter, the suit has been filed. Now, the torn agreement which was filed, that was exhibited as Exhibit 1. The defendants dispute that was the original agreement. The difference is in the Exhibit 1, which is the torn one, and it has been rearranged. The monthly rent was 4 lakhs rupees, whereas the defendants claim that the monthly rent is 1 lakh.
In that, कौन है ना?
The Exhibit 1,
yes,
which was exhibited after rearranging a torn agreement.
Okay.
The monthly rent was fixed at rupees 4 lakhs. It has been indicated that the monthly rent will be 4 lakhs per month.
4 lakhs for a
Hotel.
Oh, hotel. अच्छा, ठीक है.
4 lakhs per month. But defendants dispute that this is not the original agreement. The original agreement was somewhere at other place because they don't have the original piece of the agreement, where the monthly rent was fixed at rupees 1 lakh only.
Okay.
So this is the crux of the dispute.
Whether it is 1 lakh or 4 lakh?
4 lakh, and whether this Exhibit 1 is the genuine one or not. So the undisputedly the present defendants, they could not produce the original copy because the original copy was with the landlord. Before the appellate court filing the appeal,
the suit was decreed.
Holding that it is 4 lakhs. 4 lakhs.
Okay.
With all other benefits also. Before the appellate court, an application for additional evidence was filed. I have got the certified copy also, and in the judgment also there is a reference. Additional evidence was filed. What is the evidence? I got the copy of the original agreement, which was produced before the GST authority at the time when the hotel business was started, that is in the year 2019. That document became vital for the purpose of decision of the suit, because it could not be produced in the London trial court. London lower appellate court did not consider not even a single word on that additional evidence, and confirm the finding of the London trial court, saying that the findings are correct. I will just draw 2-3 lines of the appellate court judgment, where and how it has proceeded without considering the page 8. Page 8, paragraph 9.
Yes.
Here begins the argument of the appellant. Submissions are being recorded. Kindly turn to page 9, about 7 to 8 lines from the top. A sentence beginning with, it is further argued that as the plaintiff is not the true owner of the suit property, she filed the suit only in order to harass the defendants, and that the documents obtained under the RTI reveals that the appellant number 1 submitted the copy of the agreement executed between the in 2019 along with the electricity bills in the so and so. Even there is no reference that this is an application for additional evidence, but this document was attached to the additional evidence application, and that is on record. Now, thereafter, in the entire judgment, there is no reference to it. Kindly turn to the last part of the order, the judgment. Last part of the judgment, page 20, internal page 20.
Yes.
Then conclusion, the last part conclusion, the one but application petitions pending in the appeal are disposed of accordingly. These are the two lines by virtue of which I must say that the application for additional evidence and this vital document was not at all considered by the lower appellate court. That itself makes the judgment perverse. And why I am saying that it is
So that document which was filed before the GST authorities was never taken into account.
No. Therefore, in present appeal also I have filed an application for additional evidence along with that very document. And before going to that document, I have exhibit 1 vis-a-vis exhibit 9.
No, before that, let me just find out who are the parties here.
Pardon?
Who are the parties? Who is the respondent?
Respondent.
You are Mr. Shiva Prasad Karo. So, but who's appearing for respondent number 1 and 3, 4?
Yes, they are supporting.
You are respondent number 1, 3 and 4.
3 and 4. Respondent number 1 and 2.
Respondent 1 and 2.
1 and 2 are the.
How can you appear for 1?
Milord, I have given the authorization and
Is the husband and wife.
Can he appear?
No. As a lawyer, he cannot. If
no,
she personally appears, no problem.
That is what I am saying.
I am appearing in person.
You can appear in person for yourself.
2, only 2.
2.
Also, my Mrs. has also authorized me.
No. How can that cannot? She cannot authorize to you to on her behalf. There are some decisions of course, in case of that in the armed forces matters, persons can be authorized, but in civil matters,
special statute, there is
civil matters,
no authorization can work.
That is, today we are referring to Mr. Order 3, Rule
3.
Order 3.
Yes.
Rule 3. Now, Rule 1. This technical imbroglio we must first decide. So you can appear on your behalf. There is no problem. Etc. may be in person by recognized agent or by pleader.
Pleaders.
These 3 persons can appear
Yes.
either in person or by recognized agent or by pleader. Who is this recognized agent?
Milord.
Is Order 2. Rule 2. The recognized agent or parties by whom such appearances, application, persons holding power of attorney, authorizing them to make and do such appearances, applications, and acts on behalf of the parties, persons carrying on trade or business. In this, he will come.
In power of attorney. I
Order
don't
2.
think he has given the power of attorney for that.
Have you given a power of attorney?
Milord, I have my Mrs. has given affidavit and also.
Semitra habani gote power of attorney korek padibo na.
Milord, then I will submit it next Monday. I will submit it. But prior to that, Milord, I beg your kind lordship. Hearing the first. Milord, after they are enjoying, I don't today.
They are the appellant. Let them complete.
Sure.
Let them complete.
Sure.
You will be given an opportunity of hearing.
Yeah.
Hath ka jod ke nahi. You are an officer of the court. Why are you? The recognized agents of parties. Yes, Mr. Das. Please assist the court in this regard. I think by a power of attorney he can appear. But by a mere authorization on a piece of paper, you can't appear. That will not be treated as a recognized agent.
It must come under Rule 2.
Persons holding powers of attorney, authorizing them to make and do such appearances, applications, and acts on behalf of such attorney. There are business for and in the name of parties. जो farmer जो माने होती secretary से माने वाला.
Business.
এটা হবে না.
2A.
2A. Order 3, Rule 2A. You have to, you can appear for respondent number one only by power of attorney.
She has given and I have also filed.
Power of attorney
Yeah.
Power of attorney.
Power-
It is power of attorney. Kolkata.
Is produced it, no
Miller, I
problem.
have filed.
Power of attorney. If the power of attorney is there, then there is no problem. Mandra, power of attorney.
So now,
Today it will not be completed. Began. We will keep it as part to next week.
Miller, actually, let me see. Miller, 5.4 crores lies on them. And they are enjoying the property without paying.
Sir, this court is not interested in the amount. This court is only interested in the point which is arising for adjudication. This is a 2024 matter. You have seen the board. We have matters pending since 2003. The court cannot, court cannot just go on hearing all matters. So don't worry. Means it is a part matter, it will be complete. But not today. Yes.
Then Miller, all gives.
now, just now I am drawing a lot of attention to annexure 1 vis-a-vis annexure, exhibit 1 vis-a-vis exhibit 9.
Exhibit what?
Exhibit, I see.
LCR is there. Let me find out. Exhibit 1.
Exhibit 1 LCR আসছে
ସେ କଥା କହିଥିଲି ପରେ ତାକୁ ଆଜି ମୁଁ ଡାକିକି ସେ ଆଉ ଗୋଟେ କେସ୍ କିଛି ବାହାର କରିବା ଭାରି ଡିଫିକଲ୍ଟ।
exhibit ମୁଁ ଦେଇ ଦଉଛି ମୋର ଦିଟା exhibit 9 ଟା ନା
What is that document?
Exhibit 9 is a representation to the governor, Honorable Governor of Odisha, issued by Shiva Prasad Court, where the allegation in the plaint that one particular day, some of the present defendants, along with some of the miscreants, they entered into the house of the premises of the plaintiff, torn the agreement, and thereafter handed over the torn pieces to the. Now, there is no date mentioned in the plaint anywhere in the pleadings. But this document was produced by the plaintiff, which is exhibit 9, where the very date is mentioned. That is why this is relevant. Thereafter, I will come to exhibit 1. Exhibit 9. Life sprayer, life protection and eviction of tenant. Paragraph 5 is there. Kindly have a glance. So, showcasing their money and muscle power by hiring gundas and showing pistol, knife and other weapons, they are threatening me to evict from my own house in the midnight on 6th November 2020. This is very much relevant. It is their own admission. That means prior to 2020, the agreement was intact. Now, kindly have the glance of the additional evidence application. In this appeal also I have filed it. The petition which was filed with the lower appellate court, I have got the certified copy also. Application, additional evidence application is there.
Additional evidence application
ମୁଁ certified copy ଟା ଦେଇଛି ସେଟା ତଳ ପଟରେ ଫାଇଲ ହେଇଥିଲା appeal court. Oh, sorry. In the application for stay, I have annexed those documents. That is IN number 629.
Yes.
IN number 629. Because additional evidence application stay on the board also before the appellate court. Kindly have a glance. The annex that application. The annexure 1 to the application at page 7.
Yes.
This is the information supplied by the GST authority. Now, the agreement is attached to it at annexure 8. Page 8. This was page 8. Agreement to lease out the hotel.
Yes.
After this agreement for the GST authority, I am giving the date. Kindly come to annexure 2, page 15. This was the form. Along with this form, it was submitted. Kindly see the date 18/10/2019. Yes. That means prior to the alleged occurrence, this was also there, and there was absolutely no dispute before that date. And this agreement was produced before the government authority, the taxing authority, in pursuance of which the defendants ran the hotel. Now they kindly compare this agreement with Exhibit 1. Apart from the fact that there was an application before the trial court to compare the signature, which was rejected. Of course, the defendants have not taken any attempt to challenge the same. Kindly see the difference. First of all, in the Exhibit 1, it is only Subha Lakshmi Kaur.
Prasad is also signed.
Shiva Prasad Kaur was not there in the Exhibit 1. In the original agreement, however, both of them signed. Then next page, the 1 lakh has been turned to 4 lakhs. Page 2 of the agreement, last paragraph.
Yes.
Exhibit 1, it is 4 lakhs, but the agreement was produced for the GST authority is 1 lakh. Now the claim is a genuine one. This is a genuine one, which has been accepted, completely ignoring these documents. Whether this should be treated as a document, because I am relying upon clause B, Order 41 Rule 27, clause B, where the court may need feel the necessity of relying upon a document to consider as to whether the claim of the plaintiff is genuine or not, at least. If this is a document which has been produced before the public authority when there is no dispute, and this is a document which has appeared after the dispute, now which is to be taken into consideration?
Okay.
That is the only.
Heard in part. Let's this matter next week.
Power file to be the
कहीं देखिए ये देखो ଆପଣ वकालतनामा फाइल କରିଛନ୍ତି
ଗୋଟେ week after ପହଞ୍ଚିଥିଲେ
କରିଦେବା ସର ଆପଣ वकालतनामा फाइल କରିଛନ୍ତି ଆପଣ वकालतनामा you cannot appear both as a lawyer and as a person. You file a power of attorney for your respondent number 1. You can appear, but through a power of attorney. File a power of attorney. So I'm giving you 7 days time. Is this matter in the week commencing 20th August?
Commence a specific date.
No, 20th said a week commence. A weekly list ही civil matter उड़ा सब. पाठाने गए इट top 3-4 भीतर रहो. पाठाने गए it will and they are at the top of the list.
Interim order may be content.
Interim order to yes. Interim order.
High double
सला. हाँ? अब कुछ नहीं. List ये list सोला से list सोला.